Hey everybody, this is Professor Diffley. This is Philosophy 255, Ethics in Social Work Human Services. So this is the first video for the Chapter 8 lectures. So in this chapter, another important chapter here, we're looking at these issues here: confidentiality, informed consent, and the duty to protect are the main topics here. This builds off of what we were doing in Chapter 7, and now we're going to go into some specifics here. The chapter is very well put together, so take a look at that as always, taking a look at the reading. We're going to look at some of the code sections. We've actually looked at some of these and discussed some of these issues before. That just tells you how important they are, that they work their way through the entire class, this entire topic. But big code sections we're looking for up front are 107 and subsections within there. So that's really where a lot of this is going to be. Pretty much 107, all of it is really the focus here. But you'll see there's some other issues as well as we go ahead. So let's get into this. So let's talk about confidentiality, informed consent, and the duty to protect. So, first we're going to talk about the right to privacy, right? Interestingly, we have the right to privacy, right? But nowhere in the Constitution, the Bill of Rights, anywhere will you find this specifically enumerated. What that means is that nowhere does it actually say you have a fundamental right to privacy, that you have a clear one. Nothing specifically says that, but you could actually find it in 5 separate constitutional amendments here. We'll actually look at those amendments in the next slide there. I just want to get this out there. So back to this. The right to privacy is not absolute. That is true in all your lives. Your right to privacy is dependent upon a bunch of things where you are, right? You have less privacy in your car. Right to privacy when you're driving around than you do in your home. One, because you're out in public, all these sorts of things. We're not going to get too deep into that, but, you do not have an absolute right to privacy. The most important here we're going to see is when it comes to the duty to protect, the Tarasov decision, which we've talked about before. And we're going to see that later in slides. Previously, we talked about it where clients have the right to self-determination, but that can be overruled or overridden in certain cases where there is a serious, imminent, and foreseeable risk of harm to a client or others. It's going to be the same thing here. And again, not everybody agrees on this, and that there are significant, limitations here. But don't worry about that. That's more legal stuff. Just giving you an idea, lay of the land. Privacy is something that is always evolving throughout U.S. history. It really has changed. For one example, in the 60s, up until the 1960s, especially, all over the country, but one case was in Connecticut, there was contraception was banned. You were not allowed to have contraception. A doctor from a Planned Parenthood was actually arrested, put on a trial, and appealed and made it all the way to the Supreme Court because he was giving condoms and birth control to married couples. It was eventually determined by the court that that was an invasion of their privacy, and the only way to, but more importantly, the only way to enforce, think about it, how would you enforce a married couple from not using contraception when they had intercourse? Well, the court pointed out the only real reason, the only way to know for sure would be to have a government agent in the bedroom during intercourse, which obviously isn't going to fly. So that is your privacy there. So just know that, but just on the contraception thing, it started with allowing it for married couples, and then over the ensuing decades, it was expanded to other groups and other people. So again, these are like every right we have, they do. The meanings of them and the contours of them are fleshed out by the courts over time. But let's look at this Bill of Rights in the 14th Amendment. provisions relating to the right to privacy. Most of these are in the Bill of Rights, but it's the 14th Amendment that also gives you this. So where do we see rights to privacy? In the First Amendment, your right to believe in whatever religion you want. Remember, in the United States, to be a religion or to be a religious belief, it just has to be a sincerely held belief, right? It doesn't have to be one of the major religions. It's just a sincerely held belief. You're allowed to believe what you want. You're allowed to have, and those are private, right? I know what you don't have to tell anybody what your religion is, that sort of thing, right? I'm not allowed to ask you your religion. Usually as a teacher, and especially for the state, the reason being is the fear would be that by asking that of you, maybe there's a, what do I want to call it, a bias in there. That maybe if I find out your religion different than me, there might be a bias, that sort of thing. Other ones here, the Third Amendment, the privacy of the home, can't quarter soldiers. We can't be forced to quarter soldiers without our consent. So that is the privacy of the home. The privacy of persons and possessions, similar here to our houses or papers, right? No unreasonable searches and seizures, right? They need a warrant to be able to search your materials, search your home, that sort of thing. So that does say we do have a privacy in our homes. The Ninth Amendment here, this says that what the Ninth Amendment is sort of a catch-all here. Enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Bill of Rights was never meant to be an exhaustive list of our rights. They were the one the founders and the founding generation believed needed most spelling out based on where they were, their experiences in the 18th century. And as, of course, things change over time, and that's where you get the 14th Amendment, the Liberty Clause of the 14th Amendment. A little history, legal aside here, 14th Amendment is arguably the most important amendment to the Constitution. It is actually what gives the Bill of Rights power within the states. Originally planned, the Bill of Rights only applies to the federal government. It says nothing about what state governments can do. The 14th Amendment makes sure that states have to respect these. So what it says is no state shall deprive any person of life, liberty, or property without due process of the law. And this has been interpreted to mean you have these privacy protections here. So those are really, this is the basis for this idea of privacy. Now, if you see, it pops up here, 5 different amendments in the U.S. Constitution. This is incredibly important to Americans, and so it's going to make its way into this field as well. Let's look at state law here in Massachusetts. It is even more clear that we have a right to unreasonable, substantial, or serious interference with his privacy. So the state general laws here, Mass general laws, go even further than the Constitution, where they specifically say we have a right to privacy. And so that's important if you're going to be working in Mass. Not only do you have to understand that we have a right to privacy from the federal Constitution, Massachusetts laws also give us a right against unreasonable, substantial, or serious interference with privacy. Again, unreasonable, so what would a reasonable interference be? Again, this would be where a life or limb is in danger. We'll see that more in the Tarasoff decision there. So other things about our privacy, it's not just the Constitution and state laws, but you also have HIPAA, right? The Health Insurance Portability and Accountability Act. This protects our individually identifiable health information, that it needs to be protected, right? That companies, businesses, whoever has that has to protect that. So what is identifiable health information? In short, it's really anything that can be used to then flesh out, or some detective work, figure out who the person is, what they have, what they're being treated for, that sort of thing. So this is demographic data. Demographic data is usually age, place of birth, place of living, that sort of thing, where you work, any of that. So this is demographic related to individuals' past, present, or future physical or mental health conditions. What is being provided to the individual, what kind of healthcare, all right? So if you're going in for certain kinds of treatment, wouldn't take much detective work to figure out maybe what you, if you're being diagnosed with something. An obvious one is if you're going through chemotherapy, that's really only used for cancer treatments. And so that would be just knowing someone had undergone or is undergoing chemo begins to give out that information. Also, payment information is also not to be disclosed here. Why? Well, you could figure out what certain procedures cost. So I'm making this up now, but say a certain say a CAT scan or something like that cost, or an MRI cost $1,000, and it was the only procedure that cost $1,000. Well, if someone saw you getting billed, they could figure out it was you needed an MRI or CAT scan, and then they could do a little bit more digging there. So again, and this is going to be a theme, and we're going to see this later, and the code says this. What information is to be given? The least necessary, right? Not too much information, just the least necessary. But especially here, you have to deal with all this of not giving out this information under HIPAA. And you might be familiar with this too. At the school, we have similar provisions where we can't give out information about you as students, right? So say if a parent of yours or a family member calls, say me, and asks for information, I can't just willingly give them that information. You have protection there. You can consent to it being given, but until that's, we have the right, we have the obligation to protect privacy. So, but these are two terms that are often thrown about, privacy and confidentiality. They do not mean the same thing, and that is very, very important here. Privacy and confidentiality are two sides of the same coin, dealing with the same issue here, but we need to have the definition separated here. So, what is privacy? And people often get these two mixed up, so please pay attention to this. I guarantee you're going to have a question on this on the quiz and an exam later. So what is privacy? Privacy is the right of every person to decide what, if anything, they share with about themselves with others, right? So your right to privacy means you control what information you want out there, right? Only you should be able to decide, in most cases, again, other than extreme cases, of what information is given out. That is privacy, right? So you control, the individual controls their own information. Confidentiality, on the other hand, is what you do with that information. So especially here, say in the helping field, social work, other human services, this is what your client is going to decide, what private information they want to give to you, and then you have the obligation to hold that confidential. And so confidentiality refers to the professional obligation as a social worker and others that you're going to not reveal the information you received from the client. Without their consent, right? So obviously if they say, yes, go ahead, give that information out, that's different. But confidentiality is when you have the private information of a client, when they've shared that with you, you are under a legal obligation, professional and legal obligation, to not disclose that information without consent. So again, privacy, a person's right to decide what information they share. Confidentiality is the professional's obligation to keep that information from getting out, right? Of not just go sharing it. So really make sure you know the difference between privacy and confidentiality. So where do we see this in the code? Like I said, 107, that's where we're going to be for this. And so 107, the title, privacy and confidentiality, it should tell you right there. So one, code say you should respect your client's right to privacy, obviously. And under Massachusetts law, you have to. Beyond that, too, it says you don't solicit private information from or about clients except for compelling professional reasons. And once you do get that information, standards of confidentiality apply. So what do we mean about soliciting here? Again, how I mentioned before, as a teacher, I'm not supposed to go around asking the class what their religion is or anything like that, because there could be a bias there. It's not always clear that, someone needs to know this, right? Honestly, I mean, in my job, knowing the religions of each of you individually has zero impact on us, right? On our relationship, on our teaching, on the class, right? So the only reason, assume that why I would want to know is probably a bad reason. That's what most would say. there could be me. I'm just curious. But what we're trying to get at here is we should not be going for this. There's no compelling reason for that. So you should not be seeking out information unless there's a compelling reason to do so. And we're going to go a little further into that in the next slides, and we'll pick up here in the next video. Thank you.